Welcome to Daily Justice Files.
Court is calling 2024 CR 0443, State of Texas versus Marcelo Flores. Can I have parties announced for the record for the state?
Daniel, for the state of Texas.
Defense.
Rene Munoz on behalf of Marcelo Flores.
And are you Mr. Flores?
Yes.
All right, and probation, this is an application. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Flores, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, we're sitting on count 2 and waiving count 1.
Any objection?
No objection from the defense.
Mr. Flores, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, is your client applying for deferred adjudication or regular?
It would be for a regular community supervision, Your Honor.
All right, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea today?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That's correct.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the document entitled, I'm sorry, that's okay. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at a cap of 6 years in the prison. The state is silent on your application. They're taking in consideration 2024 CR 0444 and 2024 CR 0445. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by citing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State officer exhibit 1 and all attachments.
No objection from the defense.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
A convicted man stood before Judge Boyd knowing prison was a real possibility, but before this hearing was over, one decision would completely change the direction of his future.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, I've been given a PSI date of July 9th, but really the only thing I need is a TAP evaluation and his criminal history. Probation, how long would it take to get a TAP evaluation in custody?
There's 3 weeks, please.
Your Honor, if I may, I did in advance of this court setting, reach out to PICU, and they did have a SUD clinician, substance use disorder clinician, meet with my client, Mr. Marcelo Flores. They deemed him eligible for services at Lifetime Recovery. And they just requested, if the court were to see fit to send him there, that we keep them informed of a release plan, Judge. So, in the essence of being more efficient, it seems like he has been seen, Judge, and I do have the email correspondence.
All right, then we'll still do the TAP evaluation, but it won't have to be maybe the 3 weeks in custody. If I decide to place him on probation, he'll be released to go to Lifetime Recovery, and probation could perhaps do that outside of custody.
Okay.
So then with regards to criminal history. Renee.
Yes, no problem. I like to have my ducks in a row as much as possible. Makes it easy for.
What's your criminal history?
Like,
Have you been to prison before?
yes,
For what?
authorized uses and, drugs.
Okay.
And the NCICT says you should be right behind that judge.
All right, thank you.
And just for the record, the state did hand over the defendant's case file that does include his criminal history in the NCICT CIC.
All right, thank
Correct,
you.
yes.
To the court reporter, were you able to pick up what Daniel said?
Sorry, I said it kind of low.
Here you are. Thank you, counsel. All right, if y'all prepare for sentencing, I'll do sentencing now.
Yes, Your Honor, we're able to. We greatly appreciate it. May I be heard on behalf of my client?
Yes.
Ever since I got my client's case, Your Honor, some red flags did go up for me. I did see that he was homeless, and he has some drug offenses that he's dealing with. I don't think that, they're independent of each other. I think that, they're related. He has been obviously to prison in the past before, but it seems like his prison stays did not have anything to do with violence, but more so were symptoms of his drug usage. So that prompted me to speak with him about his options. He's adamant that he wants the chance at drug treatment to break the cycle of his incarceration, to be hopefully a contributing member to society one day. He is understanding that if this honorable court does grant him probation and sees it fit to order to lifetime, you have to remain at that facility and abide by all program requirements and conditions, as well as work the aftercare program. And hopefully they can help set him up with housing as well, Your Honor, to get him back on the right track. It's my fear if he just becomes a product of the institutional division, he won't be getting the same amount of services and care that he could be with lifetime recovery. So we're requesting that this honorable court order that respectfully, to hopefully break this cycle of incarceration that has surrounded his life leading up to this point.
All right. Do you have any family support?
Yes, ma'am.
Who?
I have, my kids' mom.
All right. How old are your children?
They're 18, 17, and 15.
All right.
And I have 2 grandkids.
All right. So state, I'm going to grant his application for probation. Do either of you have a suggestion on length of term?
What looked like a routine plea hearing quickly became something much bigger as the facts unfolded. The courtroom faced a difficult question: should this man be punished again or given one final chance to change?
Judge, the state would at least ask for 6 years.
6 years, we'd be agreeable with that, Your Honor.
All right. The court is going to find you guilty, sentence you to 6 years in the prison, suspended and probated for 6 years. Taking into consideration 2024 CR 0444, 2024 CR 0445. I'm going to want a referral to felony drug court. He's going to remain in custody. And counsel, if you want to coordinate with felony drug court, if they accept him, they'll probably accept him and then send him to lifetime recovery. But I definitely want him to get to lifetime recovery.
Okay, Your Honor. And if the referral to felony drug court goes out and if they're at capacity or something of this sort, should I bring it to the court's attention or?
No, if they're at capacity, he'll still be going to lifetime recovery and they'll probably put him on a wait list.
Okay, great.
All right, so guilty, 6 years in the prison, suspended and probated for 6 years. I'm taking the cases into consideration that the court has previously stated. He's to remain in custody until he has a felony drug court evaluation and a transfer to lifetime recovery. There's going to be regular reporting by Zoom or in person, the UA hotline until further notice. And counsel, usually I keep the UA hotline on until he's actually been in treatment for a while.
Yes, sir.
Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until further notice. So that means you're not allowed to babysit or do any of that. Do you understand? I'm going to want field visits. One time per month for 6 months. There's going to be 300 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. There's going to be 120 sober meetings in 120 days. Probation, is there anything else that's needed?
No, Judge.
Is there anything else you need from the court to be successful?
Just like that.
All right. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, so off the record, here's the thing. Maybe you came in, maybe you thought you're going to end up going to prison, but you're not. So you need to remember where you are now and what you were thinking and what you've received. And this court, to be successful on probation, communication is key. If there's an issue, let probation know. If you feel you're going to use, call a sponsor. If you're in felony drug court and you feel you're going to use, let them know. Don't get on this train where I'm not going to report, because then it's just all done. You understand?
Yes.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome.
As the hearing continued, Judge Boyd weighed every detail from the defendant's criminal history to his struggle with addiction. Instead of asking for sympathy, the defense asked for one chance at rehabilitation. In the end, the judge chose accountability, with an opportunity for change, granting probation under strict conditions and treatment. Now the future depends entirely on the defendant's choices. Do you think Judge Boyd made the right decision? Let us know in the comments and subscribe for more real courtroom stories.